So you're probably wondering how I know that so many trial lawyers struggle to retire, and many retire broke or simply have to continue working until they can't work anymore. Hi, this is Mark Wallstrom. I'm the president of Wallstrom & Associates, and the answer to that question is that I've spent over 30 years working with trial lawyers on just about all of the financial aspects of their cases, as well as their client settlement plans, qualified settlement fund administration, and other areas that have given me a unique insight into why so many trial lawyers get close to retirement and yet face this grim future. I know what you're going through. I see the mistakes that are repeated over and over, but I also have worked with other experts to address three common issues that typically lead to a trial lawyer getting on a financial treadmill of debt, high taxes, and failure to build a secure retirement. Being a trial lawyer is stressful enough, so if I can help you relieve some of that stress through some simple changes, well, I want to do that because so many of you are longtime friends and clients. So in today's video, I want to give you a quick look at problem number one, that being mistakes made using litigation financing or how you finance your practice. One of the single biggest sources of frustration for me personally is seeing my clients and friends tied into truly oppressive litigation financing deals as they're working on cases and trying to finance their practice. You see, in so many cases, the interest charges and accumulated loan balances have ballooned to such a level that in some situations I see, lawyers are getting multi-million-dollar fees only to watch as their tax bill and loan repayment literally wipe out the entire fee. In fact, in some cases, I've seen where clients owe more than the amount of the fee, causing them to have to take out a new loan just to survive, creating a situation where virtually zero of a huge case is put away for retirement. Now, I'm going to get into how you can defer or time your tax hit in part 2 of the series, as well as how to finally maximize your retirement savings and reduce taxes. But first, we have to tackle the single biggest reason why trial lawyers can't save money, and that's oppressive litigation financing deals. Now, for this video, I'm not going to get into deep weeds on how financing choices can be used to your benefit. Instead, I want you to know how the litigation finance world is changing and that you can finally take advantage of it instead of it taking advantage of you. So here's your big takeaway on litigation finance, and I want you to remember this. There is literally billions of dollars of new hedge fund, private office, and venture capital money pouring into the litigation finance marketplace. And with that rush of cash is coming a wide range of options, choices, and most importantly, competition. This means lower interest rates, better terms, more sophisticated lending tools, and finance options are appearing every single day and for all sorts of cases. For example, there are firms that will actually finance a buyout of your law practice if you want to retire, as well as offer substantially lower rates on existing financing if you use a 468B settlement trust or structured settlement on your case. You probably aren't even aware of these new tools and options, but I've been researching them closely, and I can show you which ones might apply to your particular situation. However, I want you to keep in mind, with the land rush of money, there are all kinds of traps and issues that can make your situation more precarious than before. As you can imagine, there are firms that tie you up in the underwriting process only to squeeze you on your rate when you most need the money at the end. However, I want you to keep in mind, with the land rush of money, there are all kinds of traps and issues that can make your situation more precarious than before. There are firms that will tie you up in the underwriting process only to put the squeeze on you and increase your rate when they know you need the money the most, as well as other firms who have default triggers that can kick rates up into the 30% range and impact your ability to negotiate or settle your case as a result. There are all kinds of issues, so you have to work with the firms that have a demonstrated track record of responsible underwriting, reasonable repayment options, fair interest rates, and a commitment to improving your finances. If you have a case financing issue, I can now refer you to a range of firms with capacity up to $25 million per case, but more importantly, they can craft it in a way that allows you to reasonably repay or refinance in a fashion that doesn't put your practice under excessive stress and allows you to structure your legal fee in a way that reduces or defers your tax hit while effectively managing your litigation or firm practice financial options. All right, I want to wrap this up by reinforcing rates are coming down, There's intense competition for your financing business, but there are players out there who are looking to maximize their profit at your expense. However, there's also several solid professional quality firms who are crafting unique solutions that fit your needs, not some one-size-fits-all finance option that burdens you with a crushing debt if the facts and circumstances on your case change during the process of litigation. You see, if we start with a clean and fair finance partner, you're going to see how that can lead to substantial tax savings, cash flow improvement now, and retirement assets in the next 2 videos of this series. So stick with me, check them out, and let's get you off the debt treadmill and start building a retirement pool, no matter what stage of practice you're in. I'm Mark Wallstrom, and thanks for watching.